Mr. Gimenez, I want to ask you, at the time the board raised the rates, it had a number that it claims to have written checks for these legal fees, right?
Right.
And it had invoices for services that had been rendered in 2019 for which the board had committed the company to pay, right?
Right.
Those were the invoices that you and I walked through and put the amounts down earlier, correct?
Yes, ma'am.
Beyond that, the company had, well, let me back up and say, did the company have any other invoices aside from the ones we have talked about?
Yes, ma'am.
What other invoices did the board know about at the time?
Well, I mean, all the standard operational invoices.
Mr. Gimenez, I'm just going to interrupt you because I wasn't clear with my question. I'm focused on the legal expenses.
I'm sorry, is that a question?
Yes, sir. I'm focused on the legal expenses. We've got invoices that correspond to amounts the company claims to have paid. That's one category, right?
Right.
We've got invoices that correspond to amounts the company says were invoiced and a company obligation for work done in 2019, but were not paid. That's second category, right?
Right.
And what I'm asking is there a third or fourth category that was known to the board at the time that it made these decisions?
Regarding legal expenses or other
Yes, sir. Yes, sir. I'm focused in on the legal expenses. Yes, sir.
I don't recall any others.
All right. And so with regard to time periods after 2019, the company didn't know how much it was going to owe in legal fees until it got an invoice, right?
That's correct.
And the amount of those invoices varied greatly from 1 month to the next, right?
I would have to review to, I mean, I would not know from 1 month to the next what they would be.
They were dependent upon the work that the attorneys reported having done during the period that was covered by the invoice, right?
That's correct.
And the board had placed no limitations on that work level. Is that right?
No, that's not correct.
The board had not said, for example, to its lawyers, we will not pay you more than $10,000 a month for legal work.
The board did not say that.
The board said to its lawyers, we will pay the invoices that you present us with for the legal work that you perform during the invoice period, correct?
Yes, ma'am.
One second, Mr. Gimenez, there's one thing that I would like to show you. Do you happen to recall whether the company furnished actual payment confirmation of the invoices of the attorneys in this proceeding?
Can you rephrase or restate that question?
I can. Did the company furnish canceled checks or other documents that reflected its payments during 2019 for the legal fees?
We may have as part of a PI request, I don't recall.
I ask you because I've not been able to locate them, and I thought perhaps you could direct us to them.
I don't recall us ever being asked by one of the parties to provide PUC staff. I don't recall. I mean,
The PUC asked it in request 1-7, and here's the thing, the response was one of those voluminous responses on a CD, and so I'm unsure that I have the complete set of materials. If you don't remember, then you don't remember.
I don't remember.
I do have a handful of canceled checks that I think may have been on the website, company's website at one time. I'm not sure, I can't remember. Since I withdrew 40 though, I'm gonna label these as 40 and show them to you. One second. There we go. I'm showing you what I've marked for identification as Exhibit 40.
Okay.
Can you confirm whether or not the images are images of checks that were written on company accounts to pay for the legal fees that were included in the rates? And I'm scrolling slowly. I can scroll up, down, whatever you like.
I don't, in part, yes. I'm sure that there were many previous canceled checks from earlier in that year as well. Because this only shows July of 2019. But half a year.
All right, I will see if I can find any other checks in the materials that were produced in response to the staff's request. But in the meantime, are you able to confirm these are in fact checks reflecting payments during 2019?
Yes, ma'am.
And a lot of them are signed by you, right?
Yes, ma'am.
The other signature is Mr. Nelson's?
That's correct.
Okay. So, Your Honor, I will offer Exhibit 40.
Has that been previously submitted?
It has not, because I have never found any checks in the materials.
Response?
I'm sorry, I think so. Yeah. What's the check number?
Your Honor, I would object to the rule of optional completeness. We would ask that if she's attempting to get 2 pages of these lists of checks in, that we include the entire RFI, which includes the RFI question and the entirety of the response.
Your Honor, if there are more checks in the response that I've overlooked, I would welcome that they be duplicated and made a part of Exhibit 40. If there are more canceled checks for 2019, I'd love to include them. I cannot find them.
So, rule of optional completeness is not really an objection. You have the right to complete the document. So do you have any objections to the admission of these checks and, or this exhibit, and understanding that if you believe that more needs to come in to complete the record, then that is your option?
Your Honor, I'm sorry, we're trying to figure this out on the fly. We do believe that this is the information provided in attachment to RFI Staff 17. And to the extent that that is the case, which I believe it is, I do believe that Ms. Allen has just taken a few pages out of that attachment. We would like the record to be complete, so we would request that all of the RFI 17 be entered and the entire attachment be entered.
Right.
Your Honor, my exhibit stands alone and I'm offering it. If they wish to compile a separate exhibit, we'll consider it at that time, and I'm happy to do that.
Okay. So,
Yeah.
Ms. Allen, there's the, I'm sorry, was there another objection?
Yeah, just to the extent that she's offering these, it's hearsay. I don't know, we haven't seen them. I mean, we've probably seen them, but we just got them and we're trying over here to figure out where they came from. So we can't authenticate or prove where those are, so we would object as hearsay.
Well,
Your Honor, their
the
witness
witness is,
authenticated them.
all right, so I'm going to the extent you've made an objection, I'll overrule it. And Ms. Allen, there is the same hurdle of, as far as getting these to the court reporter, the other parties, and the court. So I will admit them contingent upon you effectuating that requirement.
Thank you, Your Honor. That's being done as we speak.
Okay, and then Ms. Malden, if you want to complete the record, as is your option, you may do so. Go ahead, Ms. Allen.
Your Honor, I don't have any further questions for Mr. Gimenez at this time.
Okay. All right. Ms. Lander.
I have no questions for Mr. Gimenez. Thank you.
Mr. Gimenez, I think I know the answer to this, but I do have a question, and that is, have there been any subsequent rate changes since the March 23rd, 2020 rate decision?
No, Your Honor.
All right, thank you. Redirect?
Thank you, Your Honor. Mr. Gimenez, I'm going to direct you to page 12 of your rebuttal testimony,
Okay.
which would be marked at exhibit WOWSC3, and refer you to lines 7 through 9.
Okay.
Ms. Allen asked you questions related to the term bailed on in that section of the previously filed testimony, correct?
Yes, ma'am.
And Mr. Gimenez, would you mind reading the entire sentence from starting on page 7, starting on line 7? and it ends on line 9.
Yes. WOWSC even received correspondence from counsel from Friendship Homes that if the corporation bailed on the land transaction, Friendship Homes may assert a breach against WOWSC.
Okay. And so just to clarify, the bailed on language did not come from you, did it?
I don't recall, I don't believe so, but I believe that it may have come from that letter, but it's hard to remember right now.
But according to your testimony, did it come from correspondence from counsel from Friendship Homes?
I believe it did. I mean, I believe it.
Well, are you looking at your testimony
Yeah.
right now?
Yes, yes, I am. I assume that it did, yes.
Okay. And Mr. Gimenez, has a court found you to have committed any wrongdoing as a director?
No, yeah.
And I'm going to direct you to your rebuttal testimony, which would be the corporation's exhibit number 3, page 13. And I'm going to direct you to lines 14 through 15, and also footnote 16.
Okay.
Okay? So, Ms. Allen asked you questions or a question, something to the effect of, if you believe that, or believed that the directors, or she said you don't believe that the directors should bear the costs personally of the litigation. Remember that?
Yes, ma'am.
Okay. And in your testimony, referencing footnote 16, why do you, well, is it your personal belief that you personally shouldn't bear the litigation costs? Or is it according to state law?
It's according to state law.
Okay. And is that law referenced in footnote 16?
Yes.
Your Honor,
And
I
is
will
the-
object to this witness giving legal opinions and conclusions because I know I will not be allowed to cross-examine. He's not a lawyer, and I know that I won't be allowed to cross-examine him on his legal opinions. I would object to his giving them.
Well, he's giving his opinion on the applicability. He could be wrong, but he's testifying to his understanding that he is, or the corporation is subject to this provision. Overrule it. If you need to do cross-examination on that understanding, I'll allow that.
Okay. Then I'll withdraw the objection.
Thank you. So is your understanding that you are following state law?
Yes, ma'am.
Okay. And regarding questions that Ms. Allen asked you about related to the lawsuit involving the release of legal invoices in the AG's office.
Okay.
Is it true that you didn't release the invoices until after the corporation prevailed in that lawsuit? Okay, so even though the AG's office told you at the end of the day that you didn't need to release the invoices, you still released them?
That's correct.
Okay, and why did you do that?
We did that so that we would not incur, any additional legal costs, because there was an intervener plaintiff in the agreement that was reached between the water company and the AG's office. And so we did not want to incur any more legal expenses to fight that battle with the intervener in the settlement agreement.
Okay. All right, let's change direction a little bit to the insurance suit. When you sued the insurance carrier to recover funds and monies, was that for the benefit of ratepayers?
Yes, ma'am.
And in your opinion, are the rates unreasonably preferential, prejudicial, or discriminatory against any ratepayer member?
No, ma'am.
And in your opinion, are the rates sufficient, equitable, and consistent in application to all customers?
Your Honor, I'm objecting to these questions on the grounds that anything he might respond would be conclusory. This question and the last, I just couldn't get it in edgewise.
Well, Your Honor, I asked if in his opinion.
It's conclusory. That's my objection. It's the ipsy fix-it of somebody who really isn't even qualified to conclude, but it certainly is the conclusory statement of a witness.
Overruled, I'll allow it.
Do you need me to repeat the question, Mr. Gimenez?
Yes.
Do you believe, in your opinion, that the rates are sufficient, equitable, and consistent in application to all of your customers?
Yes, ma'am.
And in all of the answers that you provided to Ms. Allen's questions previously, where you say, if you say so, or, I'm assuming so, were you trusting that she was correct in the words that she was putting into your mouth when she asked the questions?
Yes, ma'am. That's what I intended.
And if this appeal is upheld or approved, would Windermere Oaks continue to remain financially stable and be able to provide adequate water service to its members?
No, ma'am.
And do you have any other specific clarifying testimony that you would like to make specifically regarding questions that Ms. Allen asked you previously during her cross, but where you were stopped? And if not, that's okay, but I did want to ask you that.
No, I think, no. The answer is no.
Okay, and one final question, Mr. Gimenez. When Ms. Allen asked you in depth about the financials of 2019 and the legal expenses and how they were accounted for, and I think that this was belabored quite a bit for the November and December invoices incurred versus paid. November and December were not included in the financial report for 2019, right?
Correct, yes.
Did they appear in the 2020 financial report?
Yes, ma'am.
So it's not like November and December just went hidden somewhere, right?
That's correct.
Were they were placed in the year in where the corporation actually paid those expenses.
That's correct.
Okay.
One.
Pass the witness.
I have a question just to clarify. I understood, Mr. Gimenez, you to testify that if the appeal is upheld, you will not be financially sound. Did I understand that correctly?
Yes, sir. If there is any rollback of rates, you know, to what they were previously or any of the staff recommendations, I believe that it will be disastrous for the corporation's financial health and its ability to deliver adequate water service.
So, okay, I think my confusion is with the, maybe the term upheld. So if the current rates are maintained though, then
Yes,
that would
sir.
be different.
Yes, sir. I believe the current rates need to be maintained for our corporation to continue to meet its ongoing obligations to, you know, our legal firms and our debt service.
All right,
You know,
thank you.
1.0.
That's all I needed clarification on. Okay. Ms. Allen, any additional cross based on the redirect or my questions?
Yes, Your Honor. Mr. Gimenez, I want to start with the statute that you opined about, 7.001 of the Business Organizations Code. Hang on one second and let me see if I can pull it up. Nope. Hang on one second and I'll pull it up for us so that we can all see what we're talking about. That is a provision that's, there we go, that speaks to things that a company can and cannot indemnify, correct? No, I'm sorry.
Ma'am,
Go ahead.
I'm not an attorney, so I don't know exactly.
That's what I thought, but you opined about it, so.